Welcome back to the Constitutional Clarion. A couple of viewers have asked me about the Court of Disputed Returns, what it is, what it does, and its relevance to disputes about the recent election. So that's what this video is about. First, let's go to the Constitution. What does it say? Well, Section 47 of the Commonwealth Constitution says, until the Parliament otherwise provides, any question respecting the qualification of a senator or a member of the House of Representatives, or respecting a vacancy in either House of the Parliament, and any question of a disputed election to either House, shall be determined by the House in which the question arises. Now, this is obviously a problematic provision, because although on the one hand it may seem appropriate for a House to determine disputes about its composition, on the other hand, each House is comprised of politicians from competing political parties or with different political views. If a House could determine whether a person was disqualified or an election had failed or succeeded, then it's likely that it would do so in a politically partisan way. But those words, until the Parliament otherwise provides, means that this was, in effect, just a temporary measure until Parliament chose to set up some more appropriate means for determining election disputes. It did so by including in the electoral law a provision for a Court of Disputed Returns. This is set out in Part 22 of the Commonwealth Electoral Act 1918. Section 354 says that the High Court shall be the Court of Disputed Returns and shall have jurisdiction to either try a petition, we'll come back to that word later, or refer it to trial to the Federal Court of Australia, which can then hear the matter as the Court of Disputed Returns. It also says that the jurisdiction of the Court of Disputed Returns may be exercised by a single justice, or of course it might be exercised by a full court. If the dispute involves a legal question only, it's likely that it will be decided by the High Court, acting as the Court of Disputed Returns. But if there's lots of evidence which must be presented and ruled upon, then it will ordinarily be sent to the Federal Court, as it's not practical to tie up High Court justices with such matters for a long period of time. So, for example, the case of Garbett and Liu in 2019, which I spoke about in a previous video. This is the one about the purple signs outside the polling booths that look like Australian Electoral Commission signs. That case was heard by the Federal Court as the Court of Disputed Returns. There are two different ways of getting a matter before the Court of Disputed Returns. The first, set out in Division 1 of Part 22, is by way of a petition. And no, I don't mean that kind of petition where you get lots of people to sign a document asking for something. No, the petition we're talking about here is a form of legal proceeding which asks the court to do something. Section 353 says that the validity of any election or return may be disputed by way of a petition addressed to the Court of Disputed Returns and not otherwise. An election is defined here as the choice of a person as a senator or a member of the House of Representatives, or the appointment of a senator to fill a casual vacancy in the Senate. A petition can be brought by a candidate at the election or a person who is qualified to vote at the election. But this is confined to the relevant electorate, or with respect to the Senate, the state or the territory, where the person is an enrolled voter or was a candidate. There is no capacity to challenge the validity of the entire general election. Each challenge has to be to a particular election in a House electorate or a Senate jurisdiction. Section 355 contains a critical timing constraint. Petitions disputing an election or return must be filed within 40 days of the return of the election writs or the formal notification of the appointment of a person to fill a casual vacancy in the Senate. So there's a very limited window shortly after an election has been completed for any challenge to be commenced. There's also a special power under Section 357 of the Commonwealth Electoral Act for the Electoral Commission to file a petition that disputes an election. It does this if there's been some kind of failure in the election which would make it unfair and potentially affect the outcome. An example is the Western Australian half Senate election back in 2013 when a bundle of votes was lost. The case there is the Australian Electoral Commission and Johnson. As the number of missing ballots was greater than the gap between the two candidates at an elimination stage in the count, the election was held to be void and it was later rerun. The Court of Disputed Returns has to sit as an open court, so anyone can come and see its proceedings. Section 360 gives it power to declare that anyone who was returned as elected was not duly elected. It can also declare that another candidate has been duly elected, in which case that person may take his or her seat after swearing the required oath. The Court of Disputed Returns may also declare any election absolutely void, in which case a new election must be held. The court can dismiss or uphold a petition in whole or in part. On what grounds then may an election be overturned? One ground is that illegal practices involving a breach of the Commonwealth Electoral Act or its regulations were committed in connection with the election. Under Section 362, if the court finds that a successful candidate committed or attempted to commit bribery or undue influence, then their election shall be declared void. But the court cannot declare that a candidate was not validly elected on the ground that an illegal practice occurred if it was committed by a person other than the candidate and without the candidate's knowledge, unless the court is satisfied that the result in the election was likely to be affected and that it is just that the candidate should be declared not duly elected or that the election should be declared void. Equally, the court cannot make such a finding on the ground of any illegal practice other than bribery or corruption unless it's satisfied that the election result was likely affected and it is just to do so. This is why elections are not voided even when there have been breaches of the Act or regulations, such as people voting more than once, when the margin was such that it would not have affected the outcome of the particular election. Section 365 also says that the court is not permitted to find an election void purely on the basis of procedural delays or errors which did not affect the result of the election. Due to the political instability caused by such petitions, Section 363(a) says that the Court of Disputed Returns must make its decision as quickly as reasonable in the circumstances. One of the most interesting requirements concerns how the court makes its decision. Section 364 says that the court shall be guided by the substantial merits and good conscience of each case without regard to legal forms or technicalities, or whether the evidence before it is in accordance with the law of evidence. This means that the court must get to the nub of the issue and the fairness of the outcome rather than making decisions based upon technicalities. It was argued in the case of Sue and Hill in 1999 that giving the Court of Disputed Returns the power to decide what is just in the circumstances and not being bound by the rules of evidence means that it's not exercising judicial power and is therefore in breach of the constitutional separation of powers. The High Court rejected that argument and found that the Court of Disputed Returns was still required to act judicially and that the laws empowering the Court of Disputed Returns did not breach the constitutional separation of powers. Another important feature of the Court of Disputed Returns is that Section 368 makes its decisions final and conclusive and incapable of being appealed or questioned in any way. The reason for this is to ensure finality. It's not good for political stability if such matters drag on for a long time. The second way of getting a matter before the Court of Disputed Returns is under Division 2 of Part 22 of the Electoral Act, and this deals with the disqualification of MPs and senators. Section 376 says that any question respecting the qualifications of a senator or MP, or whether a vacancy exists in either house, may be referred by the relevant house to the Court of Disputed Returns, which then has the jurisdiction to hear and determine the question. The court has the power to decide that a person was not qualified to be a senator or MP, or was not capable of being chosen and sitting as a senator or MP, and that there's a vacancy in the seat. There's no obligation to refer an issue about the possible disqualification of a member to the Court of Disputed Returns. A House retains the power to decide upon such matters itself, even though there's a risk that it would do so in a partisan manner. However, during the dual citizenship controversy in 2017, the Houses referred a number of matters to the Court of Disputed Returns to clarify the status of members and senators. You may have noticed that there are crossovers between these two routes of getting to the Court of Disputed Returns. The disqualification of a member or senator can be dealt with by a petition from a candidate or voter under Division 1, disputing the validity of the candidate's election on the ground that they were disqualified under Section 44 of the Constitution from being chosen. The margin of success is irrelevant in such cases if the candidate could not have been validly chosen or sit in Parliament. The second method is by the House referring the matter to the Court of Disputed Returns. The High Court has held that the second method is not exclusive and that the first method can be used to address disqualification issues too. The significant differences concern timing, as there's a limited window under Method 1 of 40 days, but a House can refer at any time. And the other difference is who gets to initiate it, because an unsuccessful candidate or a voter can initiate an action under Method 1, but only a majority of the elected politicians in a House can do so under Method 2. Since the dual citizenship dramas of 2017, a reform was introduced which requires all candidates to fill out a form before standing for Parliament, which provides information about the nationality of their parents and their grandparents, so that possible cases of dual citizenship can be identified in advance, and which requires candidates also to respond to questions about other forms of disqualification. At the time the forms were first introduced, there was a gentleman's agreement amongst the political parties that as long as the candidate included correct information on that form and they weren't successfully challenged during the 40 days after the return of the writ, during which any voter can bring such a challenge, then the parties won't later vote for a House to refer a matter to the Court of Disputed Returns concerning a potential disqualification arising from the information provided openly by the candidate on that form. Now, whether that understanding still applies, I don't know. But that agreement did not extend to disqualification arising from information not revealed on the form or new facts arising after the time the candidate nominated. In such a case, a House is more likely to make a reference to the Court of Disputed Returns. What all this means is that if a voter or candidate wishes to challenge the election of a member or senator on grounds that they are disqualified, then they need to commence their proceedings within 40 days of the return of the election writs. The election writs for the 2025 election must be returned on or before the 9th of July 2025, and the 40 days runs from whatever date the relevant writ was returned. The same 40-day window applies to election challenges on other grounds, such as illegal practices or other errors or failures in the election proceedings. The candidate or voter bringing the challenge would have to show that the practice, error or failure was such as to have been likely to have altered the outcome of the election. At the time of making this video, there have been a couple of very close elections in the electorates of Bradfield and Goldstein, and the Electoral Commission has agreed to hold a full recount in Bradfield and a partial recount in Goldstein. The closer the outcome, the greater the chance of being able to show that illegal practices, such as multiple voting or errors that resulted in the exclusion of votes, are likely to have made a difference. However, given the cost of bringing such legal proceedings and the risk of having to pay the other side's legal costs if you lose, a candidate is unlikely to do so unless they consider that they had a very good chance of winning any replacement election. It's sometimes the case that the person who initially was declared the winner and was then found to have been invalidly elected manages to win the seat back with an even bigger margin. Phil Cleary and Jackie Kelly provide examples of disqualified MPs who won back their seat after the causes for their disqualification were removed. There are two other peculiarities to mention here. First, while the Houses may refer a disqualification issue to the Court of Disputed Returns, they can choose not to do so. A House can even declare that a candidate has been validly or invalidly elected. For example, in 1974, the Senate overturned a government attempt to refer Senator Gare to the Court of Disputed Returns to determine if he was disqualified, and instead the Senate declared that Gare was validly a senator on the relevant date. On that, see my video about the Night of the Long Prawns for further details of that rather extraordinary story. In 1999, the House of Representatives declared on party lines that Warren Ench was not disqualified due to his interests in a company that had contracts with the federal government. Generally, it's preferable if such matters are dealt with impartially by a court rather than a partisan House of Parliament. The second peculiarity is the role of a common informer, who was an ordinary person who could sue a member of Parliament who continued to sit in Parliament when they were disqualified. But legislation and a High Court interpretation effectively killed off the utility of that method. I'll deal with it in a separate video because it's quite interesting. Thank you once again for watching the Constitutional Clarion. I hope this gives you a better idea about the Court of Disputed Returns, what it is and how it works. And as always, I look forward to seeing you again next time. Goodbye.